Hello and welcome. Thank you so much for giving up your time this afternoon, everybody. I say this afternoon. For those of you in the UK, it's this afternoon. Thank you for those who have joined us from the US. Good morning to you. And from those in the Far East in Australia, well, I say good evening if you're in Singapore, and if you're in Australia. You might be watching this on playback in a couple of days' time, because I think it's about 3 in the morning. But we are talking about the case that's got the whole world talking. So my name is David Price. I'm the senior partner of Fenchurch Law, and I am a specialist in an area of insurance known as constructional risks in the UK and builders risk in the US. Because we are talking about a US case today, I'm going to refer to that insurance product as builders risk in this talk. But as those of you who know me and have heard me speak before are probably aware, I have an unhealthy interest in defect exclusions. And you may have seen the trilogy of webinars that I recorded in 2022. Those were more of an introductory series of sessions in relation to builders risk and defect exclusions. And for today, I'm going to assume that everyone who is attending this webinar is more familiar with builders risk and defect exclusions, and you're really here to listen about the South Capitol Bridgebuilders case itself and to hear from the man at the center of the storm, David Goodman. If you are less familiar with builders risk and the defects exclusions, I hope you'll get something out of this webinar in any case, but I would encourage you to go back and have a look at the webinars that I recorded in 2022, which are all available on the Fenchurch Law website. So when I was speaking in 2022, at that stage, there were no court decisions anywhere in the world on the two most favorable defects exclusions, DE5 and LEG3. So for those listening from the US, you almost never come across the DE exclusions in the US, but they perform a very similar role to the LEG exclusions, and DE5, in my view, does exactly the same thing as LEG3 is intended to do. And then, like buses, we get three decisions that come along one after the other. So the first was actually a UK case in June 2023, and that was the first case to look at DE5 in the case of Skye and Riverstone. But that was a damp squib insofar as it discussed that specific clause. It wasn't a damp squib at all in relation to various other issues that it tackled, but in relation to an analysis of DE5, it really didn't tell us anything. And then we had the first court case anywhere in the world to come to trial in relation to the LEG3 clause in the case of South Capitol Bridgebuilders and Lexington. And then followed hot on its heels was another case from the US, Archer and Ace. If Skye and Riverstone was a damp squib with regard to the interpretation of DE5, South Capitol Bridgebuilders was the opposite. And the storm it created was no less than incendiary. Why was that? Well, it was partly because of the colourful language that the judge used in his judgment. But it was more than just the surface, it was also the substance of what was in the judgment. And two things in particular that have created a lot of interest in the builders risk market. The first is the judge's interpretation of damage and whether there was damage in this case that triggered a builders risk policy. And the second, and probably even more eye-catching, was the interpretation of the LEG3 clause itself. Uniquely in my career so far, I've come out and raised concerns about the implications of a case where a policyholder won. I've never done that before, and it doesn't mean that I think this decision necessarily was the wrong decision in the context of the case itself. And I have spoken to my guest today, David Goodman, about this case a number of times, and I'm persuaded by the way he talks about it. But it is nevertheless a case that raises issues for the builders risk market to deal with. I've written about the case, but I've written about the case from the perspective of having looked at the judgment and thinking about what the judgment means for the builders risk market. But as we all know, a case is about very much more than the judgment itself. And so today I couldn't be happier than being joined by the person who knows more about the case from the policyholder's perspective than anyone, and that's David Goodman. This is going to be the first of 3 discussions that I'm going to have in relation to issues related to the LEG clauses and the decisions that have been handed down in the US. Later in the summer, I will be having a follow-up webinar in relation to the Archer and ACE decision. And then later in the year again, I will be having a roundup webinar, which is going to be a commentary in relation to the London market's response to these cases. So without further ado, let me introduce the star of the show. David Goodman is the founder and managing member of Goodman Law Group in Chicago, who successfully represented the policyholder South Capitol Bridgebuilders in the case that we've all been talking about. David is going to be talking not just about the judgment, but about the claim itself. And we are going to tackle what I regard as being the 3 most interesting issues to come out of the judgment. The first, did we have damage that triggered the policy? Second, what's the meaning of LEG3? And the third is one that has probably received a little bit less attention, but is also interesting and remains to be finally resolved, which is how should improvement costs be calculated for the purposes of LEG3? For each of those questions, I'm going to follow the same format. So I'm first going to ask David how he put South Capitol Bridgebuilders' case. So that may be different to how it looks from the judgment. I'm then going to ask David to summarize what the judge held in relation to each issue. Could ask David to give his comments from his perspective about the judgment. I'm going to add some comments of my own from a broader market perspective. And then for each section, I'm going to invite a Q&A. So usually I would wait for questions until the very end of the webinar. But for this one, I'm actually going to invite questions during the session itself, so that if you're interested in asking questions about the interpretation of damage, you could do that after the discussion that David and I have in relation to that. If you're interested in asking questions about the interpretation of LEG3, you can put your questions immediately after that section. So a couple of housekeeping points from me before we move into the main part of the session. This webinar is going to be recorded, and all registrants will receive a link to the recording. You're also going to be sent a feedback survey, and anything you can provide in relation to that will be much appreciated. The session is scheduled to last 60 minutes, and I will do my very best to keep it to 60 minutes, but depending on how many questions we get, you never know, we might run a minute or 2 over, but I'll do my very best to get it all done within an hour. In order to ask questions, you need to use the Q&A button, which will be at the bottom of your screens. And I can see that there is already 1 question in the Q&A before we even start, so hopefully it will be relatively intuitive to work out how to use that. So let me start by thanking David Goodman for joining me. And David, before we get into the case, can you tell me and the audience a little bit about yourself and your career prior to South Capitol Bridgebuilders?
Sure, be happy to do that. I'm David Goodman. I am a business litigator. I've been litigating business cases for 35 years throughout the United States. I've tried cases in many states throughout the United States, as well as in state courts and federal courts, and I've argued appeals. With a question at the beginning before we've even begun, sounds like we've got a hot panel here. About 33 years of my 35 years have been spent with a focus on coverage issues on behalf of policyholders. For most of my 35 years, I've been a member, a shareholder in large firms. I started my own firm about 5 years ago after I was the managing partner of a larger firm in Chicago. And I began a litigation boutique because I'd always loved litigating cases and thinking as a litigator and breaking apart the issues and thinking about how to tell the story that applies to the case, to sell that story to either the jury or the judge. And in my view, there really weren't enough firms that focused on insurance coverage. So that's how I traveled in my 35 years from, again, large firms to now a small boutique where we have 4 lawyers. And it brings me to South Capitol Bridgebuilders, a case that we began working on, I believe, in 2022.
Okay, so before we talk about the loss that gave rise to the claim, David, could you tell us a little bit about the project and also the client, so we've got a bit of background?
Sure. The client is a joint venture, and we worked and have represented one of the venture partners, which is Archer Western, as you know from the other case that Dave is going to talk about later. We do a lot of work for Archer Western and related businesses. And the project was a joint venture with Granite Construction, and it was the reconstruction of the Frederick Douglass Memorial Bridge in Washington, D.C. And in that project, they were demolishing the old bridge and building a new, very beautiful looking bridge. And in the course of that construction, while they were building the abutments and the piers that would support the bridge, there was damage that was discovered to the bridge as a whole. We can talk about that and specifics of the nature of the damage. I think that that's an important thing. And it really informed our approach to the case. We got hired in this case after the insurer had denied coverage. And so the thought process that was expressed by the insurer, the adjuster, and its coverage counsel helped us in thinking about how we were going to approach our strategy in presenting the claim within the coverage. Because, you talk about the storm that the case is constructed. In my view, it's a very straightforward, simple, normal, ordinary damage case. Viewed from the context, and this is an important thing, viewed from the context of builder's risk insurance coverage.
Okay, all right. So before we get into the detail then, David, I mean, you've talked about, well, there was damage. So let me start by just asking you to outline, I'll put it in a more neutral way, because there'll be some people in the audience that say, well, there was no damage at all. We just had property that was in a defective condition. So let me just ask in a more neutral way. When the client came to you, what were the problems that they'd encountered which made them wonder if they had a claim under their builder's risk policy? And then what made you think that they did have a good claim under the builder's risk policy? So let me put up the next slide, which I don't think is actually a picture of your, sorry, I'll click onto the next slide. I don't think this is a picture of your actual concrete, but this is honeycombed concrete. Which is obviously central to your fact. So what was the problem that the client came to you with, and why did you think you had a good builder's risk claim?
So actually, this picture is very nice looking concrete compared to the concrete that we were talking about in our case. So what happened was they were building the abutments, the supports for the bridge, and the piers on which the bridge was resting. And they're very large structures. So they built those in 3 pours. And the rebar, there's rebar that ran throughout the structure all the way down to the base, and there were other pipes and other things that ran through the entire structure to the foundation. And when they pulled off the forms in connection with the completion of the 3rd pours, they noted substantial damage to the concrete itself, the exterior of the concrete. And it wasn't just though, and this is the key from my perspective, and this was the key from our analysis. The damage wasn't just damage, gee, we've got honeycombing of the concrete, but the honeycombing affected the ability of the piers to support themselves. They had supported themselves after the first 2 pours, but they no longer were able to do that, and they were integrated. These aren't things that you can view in isolation. This is a structure built as a structure connected internally throughout, and it was damaged. And so we looked at the structure itself, what was the impact of the honeycombing on the structure, and from that we identified the nature of the damage. So it's not just honeycombing. We're not, there's, and again, we could talk about honeycombing, and we can talk about when honeycombing constitutes damage. But in this case, this wasn't anything superficial. This was structural.
Okay, so we'll come on in a minute to the extent to which honeycombing itself constitutes damage, and I'm conscious that we're talking to people for the insurance market and a lot of different insurance markets, and actually in my jurisdiction, the answer in relation to whether this particular fact pattern would constitute damage may have been different to the answer that you come to in your jurisdiction. Doesn't mean one's right or wrong. They could both be right in the context of their jurisdictions, but we just want to understand why there's that difference, or potentially there's a difference between us.
Well, that's a good point, David. I think that's one of the things that was in play here, is that you need to think about that. That's one of, from my perspective, when I looked at this, I'm looking at it in the context of we were looking at it under Illinois law, but we also looked at it under the law in the District of Columbia, and frankly, the law of most of the jurisdictions within the United States. And that informed our decision and our evaluation. I think sometimes when people go into this, they take an orthodoxy without looking at it in a more nuanced way. And I think that's an important part of what we brought to the analysis.
All right. Okay. Just before we go on to talk about each of the issues, which are the main part of the discussion, just let me see if I can get to the bottom of what the key facts are. So we've got core number 3, which is inadequately vibrated, and so has this honeycombing, which means that it has insufficient strength. Correct?
Yes.
Okay. So there's one question, which is pore number 3 itself, has that suffered damage, or is that merely property that's in a defective condition? That's one question that I'd like to get to in a minute or two. But then separately, there's a question of what effect pore number 3 has on the rest of the structure. So can you tell us about the remedial works that need to be done? Because is it just as simple as saying, okay, we can fix pore number 3, so the honeycombed concrete, the concrete that's in a condition that we don't want, whether that's damaged or merely defective, is it a question of us just being able to fix that? Or as a result of pore number 3 being affixed to other parts of the structure, for instance, pores number 1 and 2, do we actually need to fix other parts of the structure which weren't in a defective condition before they had the honeycomb concrete put onto them?
Right. So I try to look at things in as simple way as possible because I'm a simple guy. So when we looked at this, the damage itself was to the structure as a whole. There was no way to repair just the damage that was found as a consequence of the third pore without impacting the other parts of the structure that had been built before this. So I didn't ever endeavor to say, to look at this as specific and limited to damage to the top half of the abutments and piers. I looked at it as damage to the structure itself, and that was how we presented the case. And I think factually that was a fit. So I don't know whether or not, I mean, we could have made an argument as to I think under the endorsement about repair, because again, I look at this as different than simply ensuing loss. I look at the LEG3 endorsement as an extension that modifies the exclusions that were in the policy. But I didn't need to do that in this case. I didn't really need to make that argument because it did have an impact on the structure as a whole.
Hold that thought, David. You come back to me later in the session in relation to whether LEG3 is an extension or an exclusion, because that's something that no one seems to be able to agree on. Okay.
Okay.
Let's pause there. You've outlined the key facts that we need to understand in order to take a view on the 3 issues. So the 3 issues, as I mentioned at the start, do we have damage that triggers the policy? So I've put the question in a way that may be a little too slanted for David's liking. I've said, was the honeycombed concrete damage or merely defective? Whereas David would probably say, well, the honeycombed concrete is only pore 3, and we're concerned with a structure that goes beyond simply the 3rd pore of concrete. Okay, but we'll talk about damage first. We're going to come to the meaning of the LEG3 clause, and then we'll finish off with how should costs of improvement be calculated. Well, I say we'll finish off. We'll finish that off in relation to South Capitol Bridgebuilders, but then I do want to say a few words in relation to the market implications of the case at the very end of the session. Okay, so asking himself the question of whether damage is properly understood to include the cost of fixing the concrete flaws that weakened the bridge. The judge found that the answer is unambiguously yes. And my question here is, so how did he reach a view that for lawyers in other jurisdictions would find so surprising? And David, just to let you know, the reason why I would find that surprising is the way that the judge has articulated that point is when he's talking about flaws, it sounds like he's talking about the creation of a finished product that was defective from the moment of its inception. And the reason why that's problematic from the point of view of an English lawyer who's looking at the question of whether there's been damage to trigger a builder's risk policy is that the test in English law for damage is there needs to be a change in physical condition that's unwanted from the point of view of the owner of the relevant property, and that either impairs the value or the usefulness of that relevant property. And the articulation of what happened by the judge in your case sounds to a lot of people from my jurisdiction as if what was created was defective from the moment of its inception, but then there was no further physical change. So it's that question mark as to whether there is a further physical change that makes us look at this case and think, you know, look, that looks potentially problematic. And the reason why that's important is because no builder's risk insurer is going to want to insure the risk of simply badly built work. So property construction work that's simply badly built and that needs to be repaired. There's no market for insuring that. So that's problematic as far as the insurers are concerned. But my question here is how did he reach a view that for lawyers in other jurisdictions would find so surprising? And the answer from the judgment seems to be that the judge looked at the dictionary and disregarded the authorities in relation to the meaning of damage. But what's your take on that issue, David? Did you want the judge to go to the dictionary definition, or was that a surprise for you? And what do you think of the approach that he took?
Well, I think he was right. I think that his approach is right. I don't think that his approach is divergent from how judges anywhere else in the United States would approach this. Damage isn't defined in the policy per se. So what you do is you look at what is the nature of the risk that's been insured. He looked to settled Illinois law, and because this was an insurance contract that was governed by Illinois law. And in Illinois law, you're trying to ascertain whether there is a term damage. What's damage? Here it has to be a physical, loss or damage. So there was, we presented, the evidence that showed that the structure was physically damaged because the integration of this defective part impacted the structural stability of the entity of the piers and abutments. And in fact, I think a lot of it had to do with our focus and our presentation, whereas the insurer's focus was they treated it as if it was a general liability type risk, and it's not. I mean, the difference between what's covered by, what we think of in the United States as builder's risk insurance and what's covered by, what you would expect in general liability insurance is different. And here there was, as I identified, there was actually a structural, an adverse structural impact, physical impact on the piers and the abutments and their ability to support themselves as a consequence of the integration of this defective construction. So I don't think it's a stretch. I don't think there's anything unusual about this. I don't think that there is anything exceptional. I think it has to do with, and the focus always should be on, what is the nature of the risk that is insured? What does it say? What does the policy say? What is the law here?
And they look at the meaning of the words. I mean, that's something that we from an English perspective would understand. We look to get to the ordinary and natural meaning of the words. But what I would say is that in England, we've got a large bank of authority in relation to what damage means. And the authorities that the English courts tend to look to in relation to what damage means, and they're definitely not restricted to builders' risk cases. They would extend to insurance cases relating to other types of insurance policy. They would actually extend to the interpretation of damage in other contexts as well. So damage in relation to not only other types of civil claims, so torts, but actually some of the authorities that the insurance judges look at in this jurisdiction would even include authorities relating to the criminal law. but it sounds, and one of the features of the judgment in South Capitol Bridgebuilders that really stuck out for me was just how dismissive the judge was of Lexington's reliance on authorities. And it sounds from what you said as if the reason why the judge didn't like Lexington's reference to authorities is because they weren't builders risk authorities. They were general liability authorities. Is that right?
Not totally. I think that was part of it. I think that the key in making good arguments in litigation is credibility and not taking positions that are unfounded or taking excerpts out of context, which is what they did. In this case, Illinois law and law in most jurisdictions in the United States is pretty clear. It's not every, but in Illinois, it's actually more challenging to establish a defect. It's not here. If the concrete itself had simply been defective and it didn't have an impact, it hadn't failed, it didn't do anything other than, was just a defect. I don't know that would have carried the day, but in this case, it was more than simply a structure that had a defect. It was a structure that had a physical defect that impacted the structural stability of these components. I think that was the part, and I think that where the court was frustrated was that the insurer ignored that. It sort of dodged that issue, and that was at the core. So they were saying there is no physical damage because the structure, this third pour, was never in an initial satisfactory state. But I think that's the wrong way of looking at it. You have to look at what was the impact. The impact here was on the structure as a whole.
So the way you've described that, I think you said there was a defect that it impaired the structural integrity of the bridge. That sort of language, I think, would be concerning to builders risk insurers, because that's exactly the sort of situation that I was describing, that generally with builders risk we would expect not to be covered. Property that's in a defective condition, it's got an impaired structural stability because it's in a defective condition, but it hasn't undergone that subsequent physical change. So one of the comments by the judge that seemed to me to be of most concern was his reference from the dictionary definition to any bad effect. So to what extent do you think the judge was influenced by that any bad effect definition from the dictionary? Because he picked on a couple of different definitions from the dictionary, but any bad effect makes it sound as if you've got property that's in a defective condition that is got an impaired structural stability as a result of that defective condition, then you've got cover, as opposed to any other definition which would require a change in physical condition.
So I think that he was looking at again, it had to do with the way we presented the evidence. The evidence that was presented that wasn't rebutted was that prior to the third pour, we had these structures that were able to support themselves, and after the third pour was added, they weren't able to do so. So the structural and they were fully integrated into the thing that was being built. As the court pointed out, the risk that was being insured was a structure that was being built. So is there damage? Because the other question that you get is it's not just whether or not there is damage, but is the damage then excluded from coverage? And so that's a different question. But I think that the initial question was there a physical detrimental change in the structure? And the answer is yes. It wasn't able to support itself anymore. I think and that's under Illinois law too. It's not like.
And that begins to feel a lot more orthodox to me. So you're talking about the structure being admittedly partly built, and we'll come back to the relevance of it being partly built or being fully built in a moment. But you've got a structure which is partly built and which is fine at that point. When you've got pores 1 and 2, the structure is completely fine. And then you add pore 3, and pore 3 isn't fine. But the result of pore 3 not being fine isn't confined to pore 3 itself. As a result of the fact that you've got this concrete which is now attached to the rest of the structure that was previously fine, the structure that was previously fine has undergone a change in physical condition which has impaired its value or usefulness. Now that description sounds to me like a completely orthodox approach to establishing damage.
I think that's right. And that's how we presented it. That's what I'm saying. When I look at this and I think about this, I don't find it to be exceptional. I found what was exceptional was the way in which the coverage was attacked, because the suggestion was you would never have coverage for something that is being constructed until effectively it's accepted. It's a builder's risk policy. That wouldn't happen until the end of the construction project, and then there wouldn't be coverage.
Okay, and now as a policyholder representative, David, I'm fully with you. I'm fully with you, because conceptually that just doesn't work. You can't say that in order to trigger a builder's risk policy, you have to have all of the contract works completed successfully before you get the ability to claim for any damage. That just simply wouldn't work, because you only get cover when you get to practical completion. Actually, once you've got to that point, if the property is in a perfect state, then you don't get any. There's nothing to insure except for specified perils. But of course, what we're not talking about, we're not talking about builders risk policies that only respond to specified perils. We're talking about builders risk policies that respond in a situation where you've got damage either caused by a defect or damage which is sustained to property that previously was in a defective condition. So I think it has to be right that you don't need to wait until the contract works are fully complete before you then got that initial satisfactory state. For me, I think you do need to have an initial satisfactory state before you have an adverse change in physical condition, but it doesn't need to be the completed work. So you've got that part of the bridge underneath pour number 3, which was built fine, that then suffers that adverse physical change as a result of pour number 3 being put on top of it. Okay, so we need to move on to leg 3 in a minute. So let me pause there and have a look and see what's in the chat box, specifically in relation to, sorry, in the Q&A box. Don't go to the chat box.
And I would throw in one thing. I just look back to, we asked when I was deposing the adjuster, because again, the policy, there certainly could have been better draftsmanship in the policy. And I asked about what the insured property, and the adjuster said, we didn't insure a bridge, we insured the building of the bridge. And so I think that also helped, to frame the issue for the court as it was thinking about the nature of the claim.
Okay. All right. So we've got. So I'll start with a general question, actually, because this is something that's useful for everyone to hear before we go into the questions that relate specifically to damage. So this is from Andrew Burt of Howden, and the question is, and this is for you, David, is all US law similar? For instance, New York seemed to have similar cases to the UK.
I think that the law varies. So, for example, I'm looking at a case right now that deals with collapse, and the structure, it's in the state of Tennessee, and the structure didn't physically come down. Is it a collapse? And Tennessee law would suggest that the structural impairment is a collapse. Again, it's a case where the courts went to a dictionary. So you have to inform yourself as to the jurisdictions, and they do vary. And that wouldn't be a structure that hasn't collapsed, that hasn't actually undergone a physical change, wouldn't be damage in Illinois.
Yeah, and I think it's true to say that one of the peculiarities, certainly from an English law perspective, for what we would regard as US insurance law, is that insurance law in the states, it is delegated to state level rather than the federal level. And so each state insurance law is going to either vary subtly from other states, or in some cases vary quite significantly. Yeah. Okay.
And I'd say that what we dealt with here in this case is more the majority of what the law is in the majority of jurisdictions. Our law is similar, for example, to New York law.
Yeah. Okay. All right. So we've got, I think, 4 questions in relation to damage. There's also a question in relation to leg, which I'll come on to later. So the first question, does a definition of damage work without a definition of defect? What do you think about that, David?
Well, I think it does, because I think that they're different issues. I think that the first is, what is the condition that we're dealing with? Has the structure been now? Yeah, I was thinking like, well, what about design? You have a defect in design that hasn't,
Well, I think you've touched there on one of the problems with the leg clauses, which is when they talk about defect in design, they're actually talking about mistakes. And with the leg clauses, the word defect in different contexts can either be referring to the condition of the property or the mistake that led to that condition, which I think is really unhelpful. I mean, I do have a view on this one. I don't think you need a definition of defect. So when you talk about damage and when you talk about defects, you're really talking about apples and pears. They're not comparable like for like, because damage is a happening, whereas defect is a condition. So you're not comparing like for like. And a builder's risk policy only responds to the cost of fixing damage. So
Right.
if you don't have damage that triggers the main insuring clause, you don't get cover. So you don't need to specifically say what a defect is. The question is a simpler one than that, which is whether we have met the test for damage. And if so, we trigger the policy, and then we're into the realms of the defects, exclusions, and so on. But if you don't trigger the main insuring clause by showing that there's been damage, then you don't need to consider the defect exclusions because you don't get through the main insuring clause in the first place.
Exactly. If you don't have damage, it doesn't matter. And in fact, the LEG3 clause distinguished says a defect isn't inherently damage.
This next question kind of hits the nail on the head and may have already been answered by our discussion. So this question is any flaw a damage, and where does indemnity come into play? Is any flaw a damage?
I don't believe so. I think that, you have to have, again, it may not be perfectly constructed, but does it have, it's physical loss or damage? What is physically
Right.
what's happened to this?
Now, if the judge in your case was talking in the reasonable tones that you've just talked, I think the whole world would be less concerned about this case than they are, because actually you've given an answer which I think we would all agree with, certainly from the London market.
Good.
Simply being flawed isn't damaged. But that's kind of what the decision in South Capitol Bridgebuilders suggests might be the interpretation. That's the problem. And that's why I was so interested to talk to you, because actually that wasn't your case.
Well, we focused the case. We tried to present it in a fashion that we look at the nature of what the claim was. We look at how it was treated by the insurer, and we looked at the policy and does it fit? In this case, certainly we were able to identify damage. We presented it in that way. We argued about what the actual damage was, and the insurer didn't rebut it. That's how the outcome comes out. So.
Right. Let me tell you, David, the questions are piling up, and I do want to get through as many as possible. So we're going to have to probably answer these quite briefly, because we've got to go on to leg 3, but it's good that the audience is interested. So the next question is, would you deem wear and tear as damage?
I don't think so.
Yeah, so I wouldn't either. Wear and tear, my view is, even though you get a wear and tear exclusion in every builder's risk policy, it's there for the avoidance of doubt, because wear and tear isn't a fortuity that triggers the policy in the first place. So I'd look at wear and tear as being akin to the concept of inherent vice. So if inherent vice is the tendency of an object to naturally degrade as a result of its internal qualities, wear and tear is the tendency of an object to naturally degrade as a result of external contacts, so ordinary and expected external contacts. So there's no fortuity there. So that would never be damage.
Right. I think that the issue would be, you still have an issue potentially with respect to materials and something that's beyond ordinary wear and tear. But I think, yeah, I agree with you.
Okay. If there was a structural integrity concern that was discovered, the insured has the option to rectify it, and hence the occurrence of loss damage. Will risk management on site then be considered a damage claim? Let me read that again, David. If there was
I'm not sure I follow it. Sorry.
Yeah, so if there's structural integrity concern that's discovered and then it's fixed, will the risk management on site then be considered a damage claim? For me, I don't think so. You might have an extension which is going to cover you, maybe a sue and labor or similar type of provision in your policy that would give you a bit of cover there, but I'd say that wouldn't trigger the main insuring clause.
And in here, for what it's worth, the insurer was consulted immediately. They sent out an engineering firm to look at and evaluate the nature of the problem, and they consulted in the repair work.
So this is Mark Plale. It's nice to see that first two attendees are both from the same organisation. The first two questioners who aren't anonymous, both from same organisation, Howden. If building on top of a defective component means that any overlaying works are automatically damaged, is that not tantamount to a product guarantee? I mean, I can see that that's a comment on what I was saying, but I don't think it does make it a product guarantee. I think if you've got properly built contract works that you then affix something to that impairs the value or usefulness, I don't think it's a product guarantee. That feels to me to be squarely within the definition of damage.
And there's actually an Illinois case, the sort of a leading case that's talked in South Capitol, just in South Capitol, in which a structure was built using defective pipes. The pipes would fail over time, and the court found that in itself wasn't damage. They were defective, they would fail, and when they failed, there might be damage, but until they did, there was no damage.
All right, okay, I'm going to need to apologize. The questions are continuing to mount up, and I'm not going to be able to ask any more in relation to damage because we need to move on to leg 3, and I can see there are already some questions in relation to leg 3, but anyone who's got a question for David that we haven't answered, please feel free to follow up afterwards. I'm sure you all know how to get hold of my email address, and I can link you in with David if you would like.
And be happy to answer any questions.
All right, thank you so much. Okay, so on to, if that subject was controversial, maybe this one's going to be even more controversial. Okay, so on to the meaning of leg 3. Leg 3 is ambiguous, egregiously so. Your judge does love a phrase.
Yeah, he actually disagreed. I said, no, of course it's not. It's not ambiguous. It's covered. But yeah, I think that he found it. Look, the words don't just flow off the lips when you read the leg 3 endorsement. It certainly could have been drafted.
Okay, so that's true. I don't think anyone in the audience would try and argue that leg 3 is well drafted. I think we would all say it's a really clunkily drafted clause, but a badly drafted clause is different to a clause that you can't understand the meaning of. So let me just preface our conversation in relation to leg 3 by asking you just to outline how the court under Illinois law would approach the issue of contra preferentem. So how does it work out, or how does it take a view on whether a clause is ambiguous or not? And then I'll outline very briefly how we would approach it under English law.
Well, essentially, if it can have multiple reasonable meanings, if you look at it and it can mean multiple things, reasonably without a stretch, then it's considered to be ambiguous. Ambiguities are generally construed against the drafter. That's the approach.
Yeah. Okay. So I think for me that's a really key takeaway from this case, which is that the law of Illinois and also the law of Florida in Archer, because law of Florida was the same in this respect. In relation to contra preferentem, says that if you've got two interpretations of the same clause, which are both reasonable interpretations, then the clause is ambiguous and you construe it against the draft. Now, the English courts would take a very, very different view to that. And the English courts use contra preferentem as the maxim of last resort. So the courts here almost never find that a clause is ambiguous, and the only situation in which they will find a clause is ambiguous is if the court cannot work out what it means. So if there are competing interpretations, then the court will come to a view on what the interpretation what the interpretation is based on their view, unless they just simply cannot come to that view, in which case they'll find it to be ambiguous.
And in this case, for what it's worth, I mean, as I said, I wasn't being facetious. I actually did argue. I do believe that our interpretation, that the clause, if you look at it in context, if you look at what it supplanted, it wasn't ambiguous. And okay. I think that.
So just summarize for briefly. What was Lexington's interpretation of what leg 3 means? What was your interpretation? And then we can have a discussion.
Yeah, well, our interpretation of what leg 3 means is that if you look at what the workmanship did, it caused in this instance, because you had this exclusion for workmanship, you had this exclusion for design and planning, etc. And those were supplanted by this particular endorsement. If you look at what the workmanship did, what was the impact? Did it cause a patent detrimental change in the physical structure of the property? And if it did, in the insured property, and if it did, the cost of repairing, rectifying, remediating that damage, that's covered. The cost that would be excluded from coverage would be the cost of an improvement. I think that's one of the issues where there might be some ambiguity. What is an improvement? Although again, I agree with the court's interpretation of what an improvement is. It's not something simply repairing. It's got to be something different than that, because you specifically call out repair. It's something different.
We'll touch on that in a couple of minutes, because I do want to treat cost of improvement as a separate topic. So you've given your interpretation of Leg 3. I'd like, if you can explain what Lexington's interpretation of Leg 3 was, and then I'm going to read to you what I think Leg 3 means, and you can tell me if you think I've got it largely right or if you think I've got it wrong.
Well, Lexington's approach was sort of odd, in that they said that, well, this is just a defect itself. It isn't damaged because it wasn't integrated into the structure, into the bridge itself. It was just a component that hadn't been integrated. And they said that since it was never in an initial satisfactory state, there is no damage, thus it doesn't even get to Leg 3. And then they said that to the extent that what we did, they said what we did wasn't actually even a repair, it would be an improvement. We're making something that was never in a satisfactory state into a satisfactory state. Thus, to the extent that Leg 3 is triggered, we're in the area of improvement as opposed to repair.
Okay, so you mentioned at the start of the session, you referred to Leg 3 as an extension.
Yes.
Is the question of whether Leg 3 is an extension or an exclusion, was that debated in your case? And if so, what's your view on it, and what did the judge hold?
Well, the judge held that it can be both an extension and an exclusion. And in this case, certainly what Leg 3 does is it modifies an exclusion that's in the policy itself. The policy excludes damage caused by workmanship. It provides coverage for the ensuing loss, to the extent that there's ensuing loss. With Leg 3, it modifies the exclusion, and in my view, extends coverage to things that wouldn't otherwise be covered. And in this instance, it would be the workmanship, the repair of damage caused by the workmanship. Okay,
all right. Let me challenge you there a little bit. So in one sense, Leg 3 is an exclusion because Leg 3 excludes the cost of improvement. Yeah, so it clearly operates as an exclusion in that respect. In what respect do you regard Leg 3 as extending cover beyond the cover that would be provided by the main insuring clause, which responds to the cost of fixing damage?
Well, so I think it's an extension only in the sense that the main insuring clause would have excluded coverage for damage caused by workmanship. And here it supplants that, it replaces that. And so it brings coverage where there wouldn't otherwise be. So in circumstances where you have a main insuring clause, which would be pretty common in the London market, that responds to the cost of fixing damage to contract works, then it wouldn't operate as an extension in that regard because you've already got cover under the main insuring clause, and it operates merely as an exclusion. Right. And I think that, again, the way we looked at it, whether it was an extension, whether it's, simply an amendment of an exclusion, I think we looked at it, again, when you interpret an insurance policy, you read it holistically. And so that's what we did.
All right. Let me open up the conversation to questions. So the first one in relation to Leg 3 says, any comparisons drawn between Leg 3 96 and Leg 3 2006 would be great. So you got any thoughts on the extent to which there is a difference in the meaning and function of the 96 and 2006 versions of Leg 3, David?
I really don't. I'll tell you this, what I've seen, and I think that this is one of the fundamental problems that I think that the insurers probably face, is that you see amendments, you see when you read Leg 3, these are generally manuscripted endorsements. And the divergence from what might have been intended and what was actually presented is often certainly should be an issue for insurers, and they ought to read them more closely.
Yeah, okay. So just to give a bit of context to this question for those who aren't familiar with the context. So the judge in South Capitol Bridgebuilders was critical of a number of different parts of the wording of Leg 3. The Leg 3 version that was in the contract for South Capitol was the 06 version, so the one released in 2006. Judge criticised lots of different parts of that clause, and one of the parts of the clause that he criticised was a part of the clause that doesn't appear in the 1996 original version of Leg 3. Okay. And as a result of the criticism of that specific wording, questions have been raised about whether the problem, insofar as there is a problem with Leg 3, it is confined to the 2006 version, or whether the problem extends to the 96 version. Now, my view, and this is a very strong view, is that the problem extends to the 96 version as well. The 2006 version was an amended version of Leg 3 that was amended in order to respond to concerns about whether the 96 version was undermined by a Court of Appeal decision from the UK called Skanska and Egger. The LEG committee, and they made clear in their guidance notes what they did, the LEG committee took advice from one of the leading insurance silks, Colin Edelman, QC as he then was, and he expressed the view that Skanska and Egger didn't actually undermine the coverage provided by Leg 396, but in order to make that clear for the avoidance of doubt, you could introduce these new words into Leg 3 2006, but in his view, the meaning of 2006 Leg 3 and 96 Leg 3 wasn't any different. And I think that's right. I don't think there is any difference in the between the meaning of Leg 3 96 and Leg 3 2006. It's just that 2006 has got some wording that is intended to be clarificatory to deal with a specific situation that has actually had the unfortunate effect of just confusing the judge in South Capitol Bridgebuilders even more than the judge was confused before. If I was advising insurers, and I never do that, I only advise policyholders, but if I was advising insurers, I'd say you've got to be extremely cautious about using Leg 3 at all. And I do think that it is necessary for Leg 3 to be redrafted.
Well, they pay, you pay a significant premium for it. And I think that the language can be negotiated. I just think that part of the issue is the lack of care in this particular instance, in the way in which the insurance was, the policy was put together. And I think that some of that was an issue for the court as well. So, again, I think that, it's being informed as to what the law is in the jurisdiction, which you're providing coverage, and being clear and consistent in the policy. I think that that'll go a long way to protecting you. And then you make an informed decision in charging premium. There's a large deductible, it's $250,000 deductible with respect to this particular claim. And so I think that those are all things that, should inform and do inform, in my experience, the insurers and underwriting risks like this.
Yeah. Okay. The next question is from Steve Coombs. Hello, Steve. Lovely to see you. What's the London Engineering Group doing in terms of modifying and redrafting the LEG clauses? Steve, there's been no public announcement in relation to that. I have a personal view, which I've expressed in public, that although we must amend LEG 3, there is, I say we, I'm not part of the London Engineering Group, I'm saying this as a market, although in my view as a market, we must amend Leg 3. I think there is also an opportunity to amend the other Leg clauses and also to take the opportunity to streamline all the defect exclusions so that we don't have two separate suites of defect exclusions in the DE clauses and the Leg clauses. We only have one. They're combined, they're redrafted, and they're made clearer. So that's my personal wish list of what I'd like to happen. We don't have any public announcement from the LEG committee in relation to that. What I do know and what is public knowledge is that the LEG committee is intending to produce its own definition of damage, and that is a watch this space. Okay. Sorry, there are so many questions. I'd like to just get to one that relates specifically to the leg clauses. Okay, hypothetically, if the cover was leg 2 opposed to leg 3, would the cost of paw 3 be excluded and then paw 1 and 2 would be covered? Very interesting question in the 3 minutes we have available. I don't think we can delve into leg 2 because leg 2 is a question or a subject all of its own. Maybe we should do a separate session on leg 2, David.
I agree.
All right.
I agree. I'm actually a big fan of talking about ensuing loss because I got to tell you, you got to look at what this amends.
Yeah.
And that's an area that's, I mean, it keeps me busy.
Yeah. Okay. All right. So thank you. So we have only a couple of minutes left. So one of the less controversial parts of the South Capitol Bridgebuilders judgment was what the judge said in relation to costs of improvement. And he said this: the context of leg 3 suggests that to improve means to make a thing better than it would have been if it were not for the defective work. What do you think about that, David?
Well, I think that's right. I think that what we did, when we presented our claim, excuse me, we took out the cost of avoiding the issue. We added different chemicals to the concrete that avoided the issues that arose from the initial work, and so we did not seek recovery of that. That would have been an improvement, and so I think that improvement has to mean something other than rectification.
Yeah, for sure it does. So when I looked at this, I thought actually that's quite a neat articulation in as far as it goes. And it seemed to me that articulation works well if you're talking about the cost of fixing damage caused by workmanship failures. My query, though, and I don't know if you've got a view on this, is what that does in relation to the cost of fixing damage that results from design failures, and whether applying this test as articulated by that means that as a policyholder you get a design upgrade without any deduction from cost of improvement.
Yeah, I think that's a much more complicated question, and it's really not. I think that's part of the problem with the endorsement is the way it's presented, because you do have that argument. I mean, what does it mean if the how do I repair the structure that's caused by design? I take a narrower view. I'd say I probably would not give the policyholder the benefit of that upgrade, the benefit of that new design, because that's probably an improvement. Just like when we changed the manner in which we constructed this, adding the different chemicals to avoid the problem, we consider that to be an improvement. I think that's consistent with the intent of the endorsement.
Yeah. So if amending leg 3 is a burning bridge, this isn't quite a burning bridge, but I'd say
the concrete bridge, we're okay.
Yeah, for concrete. So if I could add to the wish list for what the LEG committee might do, I would love to see a definition of how one might calculate improvement costs. And I've put in writing some tentative suggestions about how one might approach that, looking at whether there's a difference between the original work and the remedial works, and then looking at whether any difference produces a tangible benefit as compared with the original works, and then trying to isolate the cost of that. That seems to me that approach probably works, but I think that would require some further thinking. And at the heart of a lot of this is actually the same point, which is there are some quite tricky issues here on which the market needs clarity. And so anything that can be done in order to give clarity in the policy so that we don't have to go to court and debate these issues is probably going to be a good thing, not just for insurers, but also for policyholders. And that's where I come back in, because honestly, all I care about is what's in the interest of the policyholder. So we've reached.
You want certainty. You're buying peace of mind and something that's reasonably foreseeable. So that's
100%. Okay, so we've reached 4 o'clock in the UK, early morning in the States still. So David, thank you so much for joining me. If it was just the two of us, I would have been happy to continue for a couple of hours debating these issues, but we've got a lot of people who have got busy lives who need to get back to their desks. For everyone who's listened, thank you so much for dropping in. I really hope you enjoyed the discussion and will join me for my follow-up webinars later in the year. Thank you very much.
Well, thank you very much, and bye to you.
Thanks, David.
Bye.